Hi, I'm John Yates, Chair of the Corporate Technology Group at the law firm of Morris, Manning & Martin. And we're here today to talk about frequently asked questions in connection with 409A of the Internal Revenue Code. What we've also done is put online these questions and answers in more detail to give you a good idea of how Section 409A impacts equity arrangements, option grants, and entrepreneurial companies. So please consult the frequently asked questions to get more detailed information about our discussion. We are talking today about Section 409A and its importance to entrepreneurs and to technology executives. And I'm here with Ed Emerson. Ed is a partner in our employee benefit group. Ed, good to have you here.
Thanks, John.
Ed, give us a little background about yourself.
Sure. I've been practicing employee benefits and executive compensation for approximately 15 years. I've spent a lot of time with 409A ever since it was enacted in 2004. And just to give you a little background on that, it was enacted out of concerns that rose out of really the Enron litigation and all where the executives ended up taking all the deferred comp that they were entitled to and leaving the company bare.
Yeah, I know that it was a big problem. One of the things that we wanted to do today for the entrepreneurs and technology executives that are listening is to talk about what is 409A and, quite frankly, why it's raised as an issue, because many times in the boardroom or with accountants or with outside directors, they ask questions relating to 409A. Tell us a little bit about what is 409A, Ed?
Well, 409A is a section of the Internal Revenue Code. It governs and regulates non-qualified deferred compensation. And what that is basically compensation that's earned in one year and paid in a later year. So it's very broad in its application. It covers employment agreements, severance agreements, traditional and non-qualified deferred compensation, and it also covers equity awards.
So for any company, particularly technology companies, where equity awards, options, restricted stock, severance arrangements, bonus plans, any of those kinds of arrangements that are set up by a growing company, 409A could possibly have application.
Yes, yes it does. However, incentive stock options, if they meet the requirements, are going to be exempt from 409A, and restricted stock is going to be exempt from 409A.
Okay, tell us why it's important to be exempt from 409A and what happens if you're not exempt from 409A. So let's just say a company sets up a compensation arrangement, they set up a severance arrangement with their executives, they have a bonus arrangement, it provides for payouts over a period of time. What happens if you don't get exempt from 409A, and how do you get it to be an exempt transaction under 409A?
Okay, well, you want to be exempt from 409A if you can in order to, one, avoid its onerous requirements on and restrictions on payment of deferred compensation. And also, two, you want to be able to avoid the 20% additional tax that it levies on a recipient of that deferred compensation if there's a violation.
So in short, if you set up this bonus plan or this compensation arrangement or severance arrangement or equity structure, and you don't make it exempt from 409A, there could be a 20% penalty imposed on top of that, on top of the tax that would otherwise be due and payable?
Right. If there's a violation of one of the 409A rules, there would be an additional 20% tax, plus interest, plus any federal state income tax that applies to that compensation.
So what you want to really be careful of if you're an entrepreneur or technology company putting these plans together is the real concern might be when you have down the road an acquisition, you're selling the company a big transaction that triggers this payment, this compensation arrangement, this bonus or severance arrangement. If you're not exempt from 409A, you may be very, very sadly presented with a tax bill that could be quite significant. So you want to make sure when you set these structures up, when you set this compensation plan up, that you're exempt from 409A. So how do you get a plan exempt from 409A? What do you do when you build this compensation arrangement? How do you make sure you're exempt from it so you don't have these penalties?
Well, much of the traditional deferred comp and the bonus plans and traditional change of control agreements, there's really no way of making those exempt from 409A without requiring a continuous employment requirement and maybe doing a short-term deferral payment, a lump sum deferral payment. But with respect to equity awards and stock appreciation rights, options, you can make those type plans exempt by structuring them to be issuing the options or rights at fair market value and making sure that what you're issuing is common stock of the corporation.
So let's think about a plan now. You got a technology company and they're trying to work out a structure for their executives in the compensation area. If they grant incentive stock options, they're probably not going to have a 409A problem in the first instance. But many companies grant non-qualified stock options because there could be some advantages to that. So they grant non-qualified stock options and they grant maybe restricted stock and some other forms of equity. And that's tied to some future event vesting or potentially that those mature at a change of control point in time down the road. So with regard to those particular option grants, it's very important for the company then to be exempt from 409A, and valuation and getting an independent valuation may be an important part of that. Why do you need a valuation and how do you get one to get exempt from 409A?
Well, to be exempt, the options have to be awarded at fair market value. And so it has to be fair market value as determined under 409A. Now, 409A says that you must have a reasonable valuation taking into account all the facts and circumstances of the company. And in our Q&A, we go through what are, in question number 5, what are the kind of factors that you look at for determining a reasonable and proper valuation, whether it's profits, cash flow, historical profits, cash flow, future cash flows, liabilities, intangible, tangible assets and whatnot. We go through a full list of them, but it's key that the valuation is proper and reasonable. Now the IRS has contemplated a couple of safe harbor valuation methods that are very good for startup companies to use. One being an independent appraisal is always going to be the easiest way to satisfy the reasonableness factor for 409A valuations. The other, there is a startup company valuation safe harbor method for startups less than 10 years in business with illiquid stock, provided that the person making the valuation has the requisite knowledge and experience in a valuation area for roughly a 5-year period of time.
So let's walk through the practical aspects of this. You're an entrepreneur, you're getting ready for your board meeting, and you're going to have stock options, let's say non-qualified stock options, that are going to be presented to your board for approval. You are worried in that situation about making sure that you're exempt from 409A, and your options may have some very interesting vesting provisions associated with them. So most likely what's going to happen through our experiences, if you go into that board meeting, the question is going to be asked by the board members, have you gotten an independent appraisal? Have you gotten a third-party valuation? And what you're saying is that if we can get a third-party valuation, that's really the best way to show that you've gotten a true determination of fair market value. Now, there are other ways to do it, but our experience has also told us that outside board members, particularly where they're associated with venture capital funds, like to get those valuations and appraisals. How frequently do you need to get the valuation, assuming you use a third party to do that?
Well, evaluation's generally good for 12 months unless you've had some corporate event that has materially changed the value of the company. So roughly, and of course you wouldn't need the valuation until you're getting ready to issue some type of option or award. So for a technology company, it might be advantageous to go ahead and if you're going to be granting options over a period of time, let's say every quarter, and you're going to have quarterly board meetings, to think about going ahead and getting a third-party appraiser to conduct the valuation, to do it on an annual basis, and then every year to just update that valuation for purposes of putting you in a situation where you're always aware that it's current. With the one exception to that being that if there's been a major change in the company, you may want to come in and actually update the valuation based on that major change. Would that be correct? That is correct, John.
Okay, so let me ask one final question here. With regard to the whole notion of obtaining a third-party appraiser and getting a valuation in that regard, do you need to go to a particular group? Can you get it done by just about anybody? What are the requirements there to make sure that there's enough credibility behind the party providing that appraisal?
Well, generally there are quality and certified evaluators out there. There's people that just are doing valuations on a regular basis, companies that just do business valuations, period. They are doing 409A valuations now. I've run into a lot of accounting firms and CPAs that are handling the valuations from a 409A perspective. So there's a lot of qualified people out there. I would argue that there's also some unqualified people out there. If you're just searching the internet, it'd be good to get a referral to a very qualified valuator.
Right, and I know we have names of folks that we provide, and I'm sure board members do as well. Well, this is a very important area of the law, and it's very important for entrepreneurs and technology executives as well to be aware that 409A is out there, and it relates to many of the compensation arrangements that our clients put together. Let me say too that the frequently asked questions that we put together on our website go through these particular questions and give some responses in more detail. And we're going to be adding to this FAQ with other topics as well. Of course, you're always suggested that you contact your appropriate professional advisor for specific matters related to your company, but this will give you a good overview about 409A. Ed, thank you very much.
Thanks,
it's been very informative, and we hope it has been to our audience too. Thanks.
Thanks.